The prisoners' families were allowed a 30-minute visit once a fortnight, and Capone's family rarely failed to appear on a body. They sat with other visitors at a long table, conversing through a steel mesh screen. Foreign languages were taboo, and so Capone's mother could only gaze at him and mumble a few broken words, while her sons and daughters talked. Capone kept photographs of all of them on the wall above his cot. He once asked Rudensky, pointing to a snapshot of Sonny, "How the hell can a fat dago like me have a son that good looking?" Not long after he entered the penitentiary, his brothers brought him bitter news. Torrio had formed a partnership with Dutch Schultz. Capone sent his lifelong friend a message, urging him to break up the partnership, return to Chicago, and resume leadership of the organization. There was no reply. Capone never forgave him. He ordered his wife to tear up the bonds Torrio had been buying for Sonny every birthday, now worth more than $80,000. In August, Teresa Capone retained one of the country's foremost attorneys, William E. Leahy of Washington, D.C., to get her son out of prison. With his younger associate, William J. Hughes, Jr., Leahy reopened the question of the statute of limitations. Strangely, the trial counsel had not pressed it at all, as the government feared they might. An omission which purportedly lost the Nash Ahern firm its entire gangster clientele. The previous April, the Supreme Court, ruling on a Boston tax case, had held that an attempt to evade a tax did not constitute fraud, and that the 3-year limitation, not 6, should apply as in civil cases. Contending that Capone's case was parallel and that therefore he was illegally imprisoned, the attorneys petitioned the federal court in Atlanta on September 21st for a writ of habeas corpus. The procedure governing such petitions required the presence of the prisoner, and so Capone emerged from the penitentiary to appear for half an hour before Judge E. Marvin Underwood. The judge took the petition under advisement. On December 5th, while Capone was still awaiting the judge's decision, an era came to an end. An era without precedent in the profits it produced for organized crime. President Roosevelt proclaimed the ratification of the repeal of the 18th Amendment. At Capone's next court appearance in January, Judge Underwood cited a section of the federal statute of limitations whereby the time the offender is absent from the district in which he committed the offense shall not be taken as any part of the time limited by law for the commencement of proceedings. Between 1925 and 1931, Capone was either in the Philadelphia jail or his Miami retreat for periods totaling several years. The judge continued, "If trial counsel's motion had put in issue the question of fact as to whether or not petitioner had been within the district a sufficient length of time for the statute to establish a bar, then a denial by the prosecution might have been necessary. But this was not done, and the court, according to the allegations of the petition, overruled the motion on the ground that the 6-year limitation was applicable. The ruling should have been challenged at the trial or on appeal," Judge Underwood decided. The issue had no place in the habeas corpus hearing. That the Supreme Court later declared the 3-year limitation applicable months after the Capone trial did not affect the hearing either. Finally, on habeas corpus, only the jurisdiction of the court, whose judgment is challenged, can be called in question. Any other rule would make a federal court of a district where a penitentiary was located a court of appeals to retry all cases of prisoners who might apply for writs of habeas corpus. He dismissed the petition, and the attorneys returned to Washington. "Overpaid dumb bastards," said Capone in his cell that night. "They couldn't spring a pickpocket."